you mentioned the June 2022 law. So what else can we expect? What are you expecting that's going to create a lot of work for you, potentially, for employers in 2022, you think?
I don't have a crystal ball, so I never know what's going to happen. I think I think we may have discussed this before, but they've expanded some of the non-disclosure clauses for settlements. I think we all saw that coming for a long time. And I think one of the important things to remember is you can still have a non-disclosure as to like the amount of the settlement, just not the underlying claims, basically, which I think is important for employers to remember, because I think that's really where you want to protect the amount of money you might be paying out to discourage further litigation or vice versa. So I think that's something important to remember. But I think we're going to continue to see some expansion as to like what we need to do as employers. I don't think it's going to get easier. Unfortunately. So we'll see though.
And I know it's on top of mind for everyone. Having said that, you're right. In my settlement discussions, we don't focus on conduct. We focus on really having some heavy penalties if employee, because the tendency with social media is I got this and this, or calling up, telling their friends or their other employees, and suddenly you could have an avalanche. And so we have now advised business owners that, hey, we need to have a teeth, and you need to be open on litigating some of these issues, potentially where if you know for a fact they're picking up the phone and violating the confidentiality agreement, be prepared to file, because that's the only way you're going to prevent future. Otherwise, you're going to keep getting hit with a bunch of these, and so especially it's very suspicious when it's a very specific dollar amount and suddenly people find out. You're like, how did you find out?
Yes. And I think that you have to still protect that part of it. I think that's important for employers for sure.
So the top of mind, COVID-19. So what are some of the issues that you've dealt with, or what are some of the concerns you've heard from people?
So I think it's less of a concern now because people are sort of more built into their procedures and know how to do things. But when COVID was more widespread, and I think one of the main issues was when you do your screenings for COVID, like if you're doing temperature checks or a questionnaire or something like that, because a lot of employers, it made sense to them that you do that and then you have somebody clock in, because if they're sick, you're just going to send them straight home anyway. And so explain to employers that no, you need to do this after people clock in or add on time for it. I think that was kind of a very confusing concept. It's very similar to like what we would say, like the duffing and donning kind of stuff. But I think that was what was confusing at first, because people are like, well, I don't want them to clock in and touch all the clock in equipment if they're sick and I'm sending them home. And it's like, well, yes, but then we need to build in time for that whole process. So I think that was very confusing. And there are already class actions for companies that didn't do that. So I think that was sort of the big first wave of issues, but I think people have gotten accustomed to it. And obviously, I think right now you're going to see a lot of litigation. I don't think it's going to go anywhere, but I think you're going to see a lot of litigation about vaccine mandates.
It's interesting. You mentioned that the issue in the beginning for me was there are employees calling in concerned, saying, hey, my employer isn't providing PPE, isn't doing social distancing. And I had to caution employers because some didn't have to. They're exempted for whatever it was. They're small enough. Whatever it was, right? Mm-hmm. But I said it could be considered engaging in a protected activity that they're complaining. And if you react based on their complaining, which is technically a protected activity, you could have a wrongful termination action, right? And it's just one of those weird, is odd to tell business. They're like, so what do you mean? And I'm like, yeah, they're allowed to complain about it. It's protected. And they were like, I felt like a horrible person, like a bully telling them that. They're like, what do you mean? You mean I have to honor them complaining about this? I'm like, yes, you do. So.
Yeah, no, I think things have calmed down in that respect, but yes, that was definitely an issue too of like, well, what do we do with someone who's complaining about lack of COVID precautions, or they do not agree with the COVID precautions being taken? And it's like, you have to listen to that, you have to honor it and make accommodations where appropriate, but you can't sort of just get rid of a troublemaker, which is true in general. like you should not be doing that.
You don't have to listen to that. You don't have to agree to them. You can just listen to them. Yeah,
Exactly.
it's a conversation. I keep telling everyone it's a conversation. That doesn't mean you have to agree with them. Doesn't mean you have to do what they want you to do. You can tell them, here's why I cannot do what you're asking because of X, Y, and Z. If a valid business reason, explain it to them, put it in writing. And more often than not, it does solve it. There's some people they're going to sue no matter what. Some people are looking to sometimes, unfortunately, cross litigation because they can.